Welcome to the Ciarb Ireland Mediation Awareness video. My name is Richard Lee and I have the pleasure of introducing this short video to you, which is a series of short interviews giving you important information about mediation. I'm also delighted to say that we have a short explanation from Mark O'Mahony of Chambers Ireland in relation to the excellent business and commercial mediation scheme. Jim, in your experience, can you tell us what's good about mediation?
What's good about it is that to a very large extent what you're doing is you're not imposing a solution on anybody. You're assisting the parties to find a solution or a number of solutions themselves. Life has taught us that there are advantages in having a trusted third party neutral around. Many of us have had the experience of maybe ringing up a friend and saying, I need to have a chat with you about something. Or many of us have had in our ordinary everyday lives, we've been approached by friends and parties who've come along and said to us, look, we need somebody just to help us have this conversation. And that to a very large extent is where mediation has grown from.
Bill, is mediation a new concept in Ireland?
The idea of dispute resolution is not a new one, but mediation in Ireland has become much more of a current issue in the past decade or so, when people are recognising the value of having a third party involved who allows the parties to come to a mutually agreed resolution of their issues as between themselves. It's not that they can't negotiate their way out of it, but sometimes there are difficulties about doing that. The great advantage of a mediator is that they, in the middle, can see both sides of the equation, and they may see where common ground lies between them and where there's a potential for a future resolution. And the mediator, being able to see over both sides of the fence, so to speak, can guide parties to that common ground. The question often arises, when's the right time to mediate? There's no right time. There's no wrong time. The thing is that you should take the opportunity to mediate. The important thing is that a decision will be taken before attitudes harden, or before perhaps costs of legal proceedings become an issue. I often explain to people that if you're talking about a High Court case, the costs of getting to the point where a barrister stands up on the first day of the case to explain to a judge what the case is all about could be in the order of €50,000 of costs. Now, at that stage, the costs alone might become the issue which divides the parties. They might be able to agree on other things, they might be able to resolve other issues, but costs could become the stumbling block. If before you get that far, you enter into discussions through the process of mediation, for a fraction of that cost, you could be looking at a solution. Equally, in order to get to the point where the barrister is standing up to explain to the judge what the case is all about, it could have taken 2 years or more, sometimes longer, depending on the complexities of the case. You could be into a mediation and have the whole thing resolved and the solution implemented in under 2 months. It's that quick and it's that effective.
Richard, tell us, what are the advantages of mediation? It's cost effective. It's not as expensive as going to court. It's quicker. There's no need for formal court procedures. It's flexible and not restricted by rules and limitations of court. I was involved in a medical negligence case a number of years ago, and the injured party, by and large, just wanted an apology for the wrong that was done. That was his main concern. And I feel that if mediation had been available to him, then mediation would have delivered the apology that he sought, which for legal reasons a court can't deliver. An apology is often seen as an admission of liability. But because mediation is a without prejudice process, people can apologise if there's a wrongdoing that needs to be apologised for in mediation. Mediation will become binding if there's an agreement reached, a resolution reached, and the parties sign up to that resolution. But unless there's an agreement reached, well then the process is without prejudice to your legal rights. the parties are in control of the outcome. The mediator is in control of the process, and it's important to bear in mind that the mediator is not a judge. Another important part of mediation is that it gives the parties an opportunity to talk openly. It provides a forum. The purpose of mediation, in a sense, is to be forward-looking. It enables people to avoid permanent damage and fallout. If you go to court, what can happen is there's a winner and there's a loser, and there's a permanent divide between the parties involved. We now have a short extract from the talk given by Mark O'Mahony of Chambers Ireland at the Essential Updates talks on the Business and Commercial Mediation Scheme.
So, as a Chamber of Commerce, we decided what can we do to offer commercial mediation to smaller business. So it's not just an avenue open to larger businesses or international contracts. So we worked to establish the Commercial and Business Mediation Scheme, Business and Commercial Mediation Scheme. And I'm happy to say that, as you would have seen from the slide earlier, we actually got terrific support from the legal community. The Law Society, the barristers, the Chartered Institute of Arbitrators, the Mediators Institute of Ireland, and importantly, the Court Service. So this scheme has now become almost an annex of the court system. They're promoting it. The judiciary are hugely supportive of it. We've had some very strong support from some very high-profile judges. So all of this is just formalising that this scheme is available and open, and it's supported by the legal bodies. So this isn't something that we're running as a sort of private operation. This is supported by the public sector and the judiciary. It's very, very simple. I'll just quickly run through it just to give you a sense of if you are ever in dispute, or if you know any companies or that may have a dispute or potential dispute, contact your local Chamber of Commerce or contact Chambers Ireland directly. We deal with an expert panel of commercial mediators, and this is to address the issue I mentioned earlier on quality control. So we have a very, very small panel of experts. Some of them are former judges, some are senior counsels, experienced commercial litigators, experienced commercial mediators. Once we have a little bit of an understanding about what your dispute is, we can nominate the most appropriate mediator, someone who is experienced. So you're not going to be getting somebody who doesn't necessarily understand the business world or your sector. There's a free information session where the mediators will discuss the case with you, discuss your business, discuss what outcomes you'd like to get. After that, you'll be given an estimate of time and costs, and by agreement with the associations, this is being offered at a below cost rate for a short period of time. So there's no obligation to proceed. It's a yes/no answer then. If you wish to proceed, the mediation goes ahead, and hopefully the dispute will be mediated. If not, you can just walk away. You've learned a little bit about mediation. Maybe you've learned something about the dispute, or even some strategies you can bring back to your own legal representation. But there's no obligation to participate, and all it takes is a phone call or an email to get it started to us. The benefit to you, it's completely transparent. You'll be given, as Bill said, you'll be given costs and an estimate of time up front before you need to make any decision. The costs will be below market rate, and they will certainly in all likelihood, below what you'd pay if you went to litigate. And that's generally accepted as a benefit of alternative dispute resolution. It's quick. Typically, I'm not an ADR expert, but we hear stories that very, very complex commercial mediations can sometimes be done in 3 to 4 days. So that's back to business as opposed to waiting around for a court date. And again, quality guaranteed. The person dealing with your dispute will be someone who's got many years' experience in commercial mediation specifically, so there's no risk in terms of what you're getting.
Jim, what process is involved in mediation?
The process, from my perspective, would be that once the parties have agreed to go to mediation, well, the first thing I would do is I would meet them together for a very short period of time, probably 5-10 minutes, and I would explain the essential ground rules to mediation. Then I would break, and I would go through what I call the pre-mediation process. So in other words, I would meet with each party separately to get a full and comprehensive understanding of how they see the particular issues that they want to bring to mediation. What is the background to it? What is the impact of it? What do they feel needs to happen? What might they consider to be a satisfactory outcome? I would do that with both parties so that I have an understanding of where they want to get to. Then I bring them back and we would sign what we call then the pre-mediation agreement. In other words, a pre-mediation agreement is a simple document that sets out a few basic rules around the engagement process. It looks at confidentiality, it looks at neutrality and so on. It agrees to nothing else other than to mediate. We then commence with the mediation process itself, and where we would invite one or the other of the parties to commence, to tell their story, to set out their stall. We would then ask the other party to tell their story, set out their stall, and then we would ask them to respond to what they've just heard. We would tend to move on then and look at what we need to clarify, what we need to reframe, what the emerging agenda is actually going to look like. Beyond that then, we begin to look at what options or option might resolve each area of the dispute. And we would be anxious not to prematurely jump on any one option until we've explored all others. So there's a trafficking of dialogue and conversation between the parties as this process goes on. Some of the dialogue is in what we call joint session. The other would be in separate one-to-one meetings or caucus sessions, as they're sometimes referred to. Following that, then, we would move on to what the heads of an agreement might look like. And if the parties are there with their legal representatives, that's one of the things that I would then ask the legal people to begin to do. In other words, if we have the heads of agreement emerging, I would invite the legal representatives to begin to put what we would refer as the mediation agreement together. That's brought back, discussed, tested, and then we move on to signing and closure.
Bill, what should a good mediator be able to do?
A mediator should be able to get people to commit to the process. Even though you have a situation where the parties are very much at odds, a mediator should be able to get them to focus on the future. Again, remember, in court proceedings, people are focusing on the past, and they're analysing to the nth degree what has happened and what has divided the parties. And they're trying to accentuate the positive of their own side and depreciate the negative. They're trying to point out all the infirmities of the case on the other side. A mediator will get people to stop that kind of behaviour and focus on the future, what they need to try and get an agreed outcome for both parties, and sometimes for more than both parties. So a mediator will get them to commit to that process. Equally, a good mediator will do a reality check with people and very subtly burst the bubbles of expectation, get them to question whether their expectations of potential outcome, or what they might even have been told by their lawyers is a guaranteed outcome, whether that's realistic. And because it's coming from a disinterested, neutral party, and it's reflecting back what is being said to them, they begin to wonder about that, and they get to think about it and look at it from an objective point of view, not just a subjective point of view. Equally, a mediator, while bursting the bubbles, doesn't get into evaluating the case, doesn't tell them that they're wrong, but gets them to question and to think about what they've actually been told. And there can be no guarantees in litigation, and that's a matter that people need to understand.